Postnuptial agreements in Illinois. Divorce changes everything in both parties' lives and in their children's lives. However, the status quo of living in misery and distrust cannot remain either. There must be some kind of half measure, some kind of remediation in between marriage and divorce. Often, parties will look to a postnuptial agreement, also known as a postnup, or an antenuptial agreement, as a way to delay divorce and set new terms for an eventual divorce. Why a postnuptial agreement can be a good idea in Illinois. When divorce is a possibility, but not a certainty, it may be a good idea to set the terms of that divorce in advance via contract. If the terms of a potential divorce are not set in advance, the terms of the potential divorce will be the Illinois Marriage and Dissolution of Marriage Act, 750 ILCS 5, et al. Marital property that would, normally, be divisible can become non-marital and, thus, non-divisible in an Illinois divorce. A postnuptial agreement could be entered into reflecting that the parties' fiscal relationship has completely changed over the years. A postnuptial agreement is often an agreement that governs the separation of the parties. Furthermore, if there is already a prenuptial agreement, the only way to modify that prenuptial agreement is with a postnuptial agreement. What conditions can you put in a postnuptial agreement? Under Illinois law, almost anything can be bargained for in a postnuptial agreement. Usually, the division of property and maintenance is simply prescribed in advance by a postnuptial agreement. Some parties may want to include a clause that gets triggered by another party's behavior, and this is allowed. The behavior that is most likely to trigger a clause in a postnuptial agreement is adultery. There is no Illinois case law specifically regarding adultery triggers in a prenuptial or postnuptial agreement, but there is plenty of case law from other states which is persuasive if not controlling. In reality, after adultery, the non-adulterous spouse is trading additional time married to possibly reconcile in exchange for the terms outlined in the postnuptial agreement. Adultery does not even need to be mentioned as a trigger in a postnuptial agreement because either party can get divorced anytime they want under the conditions of the divorce. If provable adultery triggers a different award of assets or maintenance, the unconscionability of the award may come into question. Enforcing a penalty in a postnuptial agreement will be challenging, as the facts triggering terms would have to be proven with competent evidence. How to ensure a postnuptial contract is valid in Illinois. A valid postnuptial agreement is a contract between you and your spouse. The first step to proving a postnuptial agreement is valid is proving that it exists. The party invoking the terms of the postnuptial agreement must produce the postnuptial agreement and testify to the postnuptial agreement's authenticity. Unless the signatures are proven fraudulent, the postnuptial agreement will be deemed valid. The postnuptial agreement in written form is the offer. The signature on the postnuptial agreement is the acceptance. The terms of the postnuptial agreement are the consideration. The postnuptial agreement needs to have specific terms that the parties can follow and the court can enforce if those terms are not followed. If the postnuptial agreement is valid, that postnuptial agreement will be enforceable. How to challenge a postnuptial agreement in Illinois. Although an agreement executed during the marriage which modifies the legal duties of married people to one another may be void against public policy. Post-nuptial agreements determining the rights of spouses to property or maintenance are valid and enforceable so long as 1. An unforeseen condition of penury is not created due to lack of property resources or lack of employability. 2. The agreement is entered into with full knowledge and without fraud, duress, or coercion, and 3. The agreement is fair and reasonable. Warren v. Warren, 523 Nebraska 2D 680 Ill. Appellate Court, 5th Dist. 1988. Penury means extreme poverty. Any agreement that left one spouse in extreme poverty would be unconscionable. Agreements regarding the disposition of property and maintenance are binding upon the court unless they are found to be unconscionable. In Re Marriage of Hightower, 358 Ill. App. 3D 165, 171, 2005. If unconscionability and fraud cannot undo a postnuptial agreement, duress may be an option to invalidate the agreement. Duress includes oppression, undue influence, or taking undue advantage of the stress of another to the point where another is deprived of the exercise of free will. Evidence of duress must be clear and convincing before a court may set aside a marital settlement agreement on this basis. In Re Marriage of Richardson, 606 Nebraska 2D 56 Ill. Appellate Court, 1st Dist. 6th Div. 1992, citations omitted. Temporary orders when a postnuptial agreement exists. During the course of an Illinois divorce, either party may petition or move for temporary maintenance or temporary support, accompanied by an affidavit as to the factual basis for the relief requested. 750 ILCS 501, A1. Child support cannot be contracted for outside of an Illinois divorce court, so temporary child support can always be requested. Temporary maintenance may be contracted away. Parties to a divorce can also request interim attorney's fees to aid in their divorce litigation. Postnuptial agreements will often include clauses stating that a party cannot ask for temporary support or attorney's fees. The language of the postnuptial agreement must be examined closely to determine the agreement's exact terms. Postnuptial agreements can either make an Illinois divorce much easier or much more complicated. If you are interested in drafting, enforcing, or invalidating a postnuptial agreement, contact the law office of Russell D. Knight today at 773-334-6311 to speak with an experienced Illinois divorce attorney.